He laughed out loud in my courtroom and said, "Judge, this case is a joke," right before I opened a folder marked Hidden Addendum. If you enjoy courtroom drama where justice served comes from truth, stay with me until I explain the verdict. I want to be clear from the start. This is a dramatized story inspired by courtroom lessons. All names, places, and events are fictional, and I'm sharing it to teach, not to expose anyone. I have served as a judge for a long time, and I have learned something that still guides me today. The law is not just about rules. It is about people. It is about accountability for harm and compassion for the human heart that sits behind every mistake. I once had a case where a teenager stole a bike, not for fun, but because he was scared to walk home in the dark. That case taught me to look at choices clearly and still see the person making them. But it also taught me this: compassion does not erase responsibility. The case I'm telling you now took place in Lakewood County Courtroom, in a quiet building that holds loud emotions. On the left side of the room sat Maria Torres. She was a small business owner. She dressed neatly, but I could see her hands shake when she tried to hold her papers still. Next to her sat her lawyer, Olivia Hayes, calm and prepared. On the right side sat Daniel Carter, a well-known investor in our fictional city of Riverton. He came in wearing a tailored suit and a confident smile. He did not look at Maria. He did not look at the court clerk. He looked at the ceiling like he was waiting for a show to start. His lawyer, Jordan Blake, whispered to him more than once, but Daniel waved him off as if the whole process was an inconvenience. The claim was simple in plain language. Maria said Daniel promised to fund her business expansion. She said he pushed her to sign a deal quickly and then used that deal to squeeze her, freeze her accounts, and try to take her company. Daniel said Maria was too emotional and bad with numbers. He claimed he did nothing wrong. He said he only used the contract the way it was written. If you've ever wondered how a legal story can turn on one page of paper, keep listening as I walk you through it. Maria owned a small chain of cafes called Sunlit Corner. In our fictional town, it was the kind of place where nurses grabbed coffee after night shifts and teens studied after school. Maria did not come from wealth. She built it slowly, one customer at a time. Then Daniel Carter showed interest. He offered a big investment, and he offered something else too: prestige. To Maria, it felt like someone had finally seen her hard work and believed in it. In court, Maria spoke softly, but her words were steady. She told me Daniel invited her to a private meeting. He praised her. He said he wanted to help real people grow. He offered funding in stages. He also offered to connect her with a landlord for a larger location. Maria said she signed because she trusted his confidence. She also said she signed because she felt pressured. The contract was thick and the meeting moved fast. Daniel's team used friendly words like partnership and shared success. But later, when Maria asked for the second stage of funding, she said Daniel delayed and delayed. Then he demanded repayment of the first stage early with fees and said he could take control if she missed even one deadline. Daniel's lawyer stood and said, "This is business. Business is not personal." That is a common line. But in my courtroom, the law does not treat people like machines. Contracts matter, yes, but so does honesty, so does fairness, and so does what both sides truly agreed to. Daniel took the stand, and his confidence filled the room like perfume. He smiled at the jury box, even though there was no jury in this case. This was a bench trial, meaning I was the one who would decide the facts and the verdict. Daniel spoke as if he was doing me a favor by showing up. He said Maria was a dreamer, and he was a realist. He said he did exactly what the contract allowed. When his lawyer asked if he respected the court, Daniel nodded quickly and said, "Of course." But the way he said it felt like he meant, "Of course I'm winning." Then Olivia Hayes asked him one simple question. "Mr. Carter, did you ever tell Ms. Torres that she would keep full control of her company unless she chose to sell?" Daniel paused. He smiled. "I told her she would do great," he said. Olivia nodded. "That's not what I asked." Daniel's smile tightened. "I don't remember the exact words." That was the first moment I felt the room shift. In courtroom drama, tension is not always loud. Sometimes it is quiet, like a glass about to crack. Olivia then introduced emails. Not hundreds, not confusing spreadsheets, just a handful, printed and organized. She showed messages where Daniel wrote things like, "We are building this together, and you stay in the driver's seat." Simple phrases, human phrases. Jordan Blake objected, saying those were just words, not binding promises. He argued the signed contract mattered more. He was right about one thing. A signed contract is powerful. But I also know this. If someone uses friendly promises to push a person into signing, then hides the real trap in fine print, the court must look closely at what was truly going on. I asked Maria to explain the harm in her own words. She did not attack Daniel. She did not call him names. She said, "I couldn't sleep. I stopped eating. My staff asked me if we were closing. I didn't know what to tell them. I felt like I was drowning and everyone was watching. There was no graphic detail, no shouting, just the weight of stress that can change a life. And that mattered to me. Please share in the comments what you think matters most in justice, strict rules, or fair outcomes that still follow the law." The next witness was Marcus Reed, a former assistant who worked for Daniel's investment firm, Greystone Capital Partners, a completely fictional organization. Marcus looked nervous, like he was afraid of being in the same room as Daniel. But he showed up, and that takes courage. Marcus said he handled paperwork and scheduling. He said he had seen Daniel use standard pressure tactics before. Not illegal tricks, Marcus explained, but timed meetings, fast signatures, and big smiles. He said Daniel liked deals that gave him options. Jordan Blake tried to paint Marcus as bitter. He asked if Marcus had been fired. Marcus admitted he had resigned after a disagreement. Jordan implied Marcus was seeking revenge. I watched Marcus closely. I asked him direct questions. I kept my voice calm because when a witness is nervous, anger only makes the truth harder to reach. Then Olivia asked Marcus about an addendum. Marcus swallowed. "There was an extra document," he said. Jordan snapped up. "Objection. Where's this going?" Olivia replied, "To the center of this case." I allowed it. Marcus said Daniel sometimes had side papers. Not always. Not for every deal. But for deals where the other person had less power, Marcus said there was sometimes an addendum that looked protective, like it was meant to help the smaller party. Marcus said it was used like bait. He said it made people trust Daniel more. Daniel leaned back in his chair, still smiling. He looked at Marcus and said, softly but clearly careful, "I stopped the moment right there. I reminded everyone that witnesses must be allowed to speak without pressure. I did not raise my voice. I did not shame Daniel. I simply made the boundary clear because the courtroom is a place for facts, not intimidation." Marcus then said something that made the air feel thin. He said the addendum in Maria's deal was labeled Addendum C, and it was supposed to be attached behind a tab. He said he remembered it because Daniel told him if she ever tries to fight, it ends the fight. Olivia asked, "Did you see it get attached?" Marcus hesitated. "I saw it on the desk," he said. "I can't say what happened after I left the room." Jordan Blake stood up quickly. "So you're guessing." Marcus shook his head. "I'm saying it existed." That is when Olivia asked for Daniel's version of the contract, the one his side brought to court. Jordan handed it over with confidence, like it would prove everything. I turned pages slowly. I have read thousands of contracts, and I have learned not to rush through paper when someone's life is tied to it. Olivia then handed me Maria's version of the contract, the one she had in her files. On the surface, they looked the same. Same logo, same signature page, same page numbers. But I noticed something small. A tab label on Daniel's copy read Schedule 4. Maria's copy had Schedule 4 too, but the paper behind it felt thicker, almost like something had been placed there and removed. I did not announce my thought yet. I simply noted it. Then Olivia requested permission to present one more piece of evidence, a scanned set of closing documents she had recovered from a secure email archive. She explained that Maria had forwarded the full packet to herself the night she signed because she was proud and wanted to keep a record. Jordan objected again, but the scan had clear date stamps and matching signatures. I allowed it. Olivia placed the scan on a screen, and then she zoomed in. There, behind the Schedule 4 tab, was a page titled Addendum C. The courtroom became completely silent. No coughing, no shuffling. Even the ceiling fan seemed loud. Daniel's smile was gone. Not replaced with fear, exactly. More like surprise, the kind a person feels when a locked door suddenly opens. Addendum C was short, written in plain language for a contract, which is rare. It stated that if the investor failed to deliver the promised second stage of funding by a set date, and if that failure caused harm to operations, then the investor would lose certain control rights. It also stated that any attempt to force early repayment during that same period would trigger a penalty payment to the company, meant to keep employees and vendors protected. In simple terms, it was a safety net for Maria, a hidden seatbelt. Jordan Blake tried to speak, but his words came out strained. Your Honor, that addendum is not in our executed copy. Olivia answered calmly. It is in the executed scan, with Mr. Carter's initials at the bottom. I looked down at the scan. Daniel Carter's initials were there, neatly written. I asked Daniel to step back to the stand. I asked him plainly, did you initial this page? Daniel said, I initial a lot of pages. I asked, did you see this page when you signed? He hesitated. I don't recall. That answer mattered. In court, I don't recall can be honest. People forget. But when a person claims a case is a joke, yet cannot recall a page with their own initials, it raises a serious question about accountability. If you want more stories where a judge explains the verdict in simple terms, consider following this channel so you don't miss the next case. Now I had to decide what was true and what the law required. This was not about punishing someone for being rich. The law does not care about someone's bank account. It cares about actions, agreements, and harm. I explained in court that a contract is not only what one side chooses to keep. It is the full agreement that both sides signed. If Addendum C was part of the signed deal, then it mattered. If it was removed later, that was deeply serious. But I also stayed careful. I did not accuse anyone of a crime in the middle of a civil case without clear proof. My job was to decide the dispute in front of me, whether Daniel broke the agreement and whether Maria deserved relief. So I asked focused questions. I asked Maria, did you ever see Addendum C when you signed? Maria blinked, surprised. I don't remember reading that page, she said honestly, but I remember the packet. I remember there were tabs. I remember I signed where they told me to sign. I asked, did you receive the second stage of funding on time? Maria answered, no. I asked Daniel, did you delay the funding? Daniel said, we were evaluating market conditions. I asked, did you demand early repayment during that period? Daniel's lawyer tried to answer for him, but I insisted Daniel respond. Daniel said, yes, because she was at risk. I nodded. So you delayed the money you promised, then demanded money back early, and tried to take control when she struggled. Daniel started to protest, but I raised my hand gently. Let me finish, I said. This is where compassion and accountability both matter. I could understand business fear. Markets can change. Investors can worry. But fear does not give someone the right to create harm through unfair control. Jordan Blake argued that even if Addendum C existed, it was just one page and did not change the main deal. He said Daniel had to protect his investment. Olivia Hayes responded that Addendum C was the exact page that limited Daniel's power, and that was why it was important. She argued that Daniel used pressure, then used the contract like a weapon, and that Maria and her employees paid the price. I took a short recess to review everything again. I read the scan, the dates, the initial marks, and the payment timeline. I compared both physical copies and the digital packet. When I returned, I could feel how tense the room was. Maria sat still, hands clasped. Daniel sat back, but he was no longer amused. I began my ruling in a calm voice, because when emotions are high, clarity is a form of kindness. I explained that the law, in simple terms, expects people to keep their agreements and act fairly. If a deal says you must fund by a certain date, you do it. If you cannot, you communicate honestly and work out a fair solution. You do not hold power over someone and tighten it until they break. Then I addressed Addendum C. I said that the scanned packet showed it was part of the signed agreement. It carried Daniel's initials. It matched the tab placement. And Maria's copy showed signs that something had once been behind that tab. I explained that when two versions of a contract appear, courts look for the most reliable proof of what was signed at the time. In this case, the time-stamped scan was strong evidence. Then I told them what that meant. I said Daniel Carter breached the agreement by failing to deliver the second stage of funding on time and by triggering the early repayment demand during the protected period, which violated the safeguard that Addendum C created. I also explained the remedy in plain language. A verdict in a civil case is not about sending someone to jail. It is about fixing harm as best as money and court orders can. It is about justice served through fair correction. I ordered the following. Control rights Daniel claimed under the main contract were suspended. The early repayment demand was void, and Daniel was required to pay the penalty amount listed in Addendum C to the company. That money was not a bonus for Maria. It was meant to stabilize payroll and pay vendors who had been left hanging. I also ordered both sides to meet with a neutral mediator to set a clear future plan. Either Daniel could continue as a limited investor under the safeguards, or Maria could buy out his stake at a fair price set by an independent evaluation. I looked directly at Daniel as I spoke, not with anger, but with seriousness. I told him, the law allows investment. It also requires responsibility. Power does not excuse you from fairness. Then I said the words that ended the case. My verdict was in favor of Maria Torres. The courtroom became completely silent again. This time, the silence was not shock alone. It was understanding. It felt like everyone in that room could finally see what the case was really about. Not ego, not money, but the line between partnership and control. If this legal story is making you think, take a moment to tell someone you trust about it, because conversations about accountability can change real choices. Maria closed her eyes for a second, like she was finally breathing. Olivia placed a gentle hand near Maria's elbow, not dramatic, just supportive. Maria did not celebrate. She looked relieved and also tired, the kind of tired that comes after months of fear. Daniel sat still. He did not explode. He did not shout. He simply stared at the table in front of him. I watched him carefully because I have seen that moment before. It is the moment when a person realizes the courtroom is not a stage. It is a place where actions have weight. Jordan Blake quietly gathered papers. He looked disappointed, but he stayed respectful. That mattered to me. Lawyers can fight hard and still honor the process. As people filed out, Marcus Reed passed by the bench area. He did not smile. He did not seek praise. He just looked relieved that he had told the truth. After the room cleared, I stayed seated for a moment, thinking about how close Maria had come to losing everything. Not because she was lazy, not because she was careless, but because she trusted someone who treated trust like a tool. That day reminded me why the justice system must hold space for both compassion and accountability. Compassion is not pretending harm did not happen. Compassion is seeing the human cost and still having the courage to name what is wrong. Accountability is not revenge. It is the honest statement. Your choice affected another person, and you must answer for it. The law exists to protect people who have less power as much as it protects those with more. And when someone walks into court believing the process is a joke, the most powerful answer is not anger. The most powerful answer is a fair verdict, explained clearly, with justice served in a way that teaches rather than destroys. If there is one lesson I hope you carry with you, it is this. Read what you sign, keep your promises, and remember that your success does not give you permission to treat others like they are replaceable. And if you want to keep hearing courtroom drama where a judge explains the verdict with calm truth, stay close, because the next case might challenge what you think you know about fairness.